Okay, we're going to go ahead and get started. Sorry, we're running a little bit behind schedule. We are speaking today about John Doe subpoenas and how they pose a threat to both online speech and privacy. So I'm going to go ahead and get started and introduce myself and my co-panelists. My name is Natalie Nicol. I'm an attorney focused on speech, online speech, privacy, and intellectual property issues. To my left is Kathy Gellis. She's an attorney with a practice focused on intellectual property, free speech, intermediary liability, and other cutting-edge legal issues. She's the founder of Digital Age Defense, which is a project focused on the convergence of criminal law and technology. Kathy recently quashed a libel tourist foreign subpoena that sought to unmask an anonymous blogger who had made allegations of misconduct against a wealthy St. Lucian executive. And on the far end is Erin Russel, who is an attorney who manages the Russel law firm. She has extensive experience representing non-party subpoena targets and John Doe defendants in cases in federal court throughout Illinois, Wisconsin, Georgia, and Colorado, and state courts in Illinois and Georgia. She's defended alleged BitTorrent downloaders and subpoena targets in mass BitTorrent cases in both federal and state courts. So what we're going to start with is just briefly discussing what a Doe subpoena is and in what types of cases we see these come up. So I wanted to toss that to my co-panelists, and they'll get us started.
Which one should I go first?
Go ahead, Kathy.
All right. So, one of the differences between what I did and what Erin did is actually maybe it makes sense for Erin to start. Her practice involves a lot of copyright subpoenas, all connected with a claim filed in federal, for the most part, filed in federal court and under the federal rules of civil procedure. Whereas my subpoena that I quashed had to do with there was an action somewhere else. Mine was, they're called foreign subpoenas. In this case, it was very foreign because it was filed in England. And it was connected to an action there, a lawsuit somewhere far away, and they had to come and domesticate the subpoena in the jurisdiction of the intermediary who had the information that people were looking at. Well, now that I've started, I might as well continue a little bit. So mine was, there was a libel tourist who didn't like what an anonymous blogger had said about him. So he went to a court in England, said, I've been defamed. I want to sue this person. So the court said, oh yes, under English law, you've totally been defamed, and I'm going to give you a discovery order that you are going to take to Automatic, which is the company that owns WordPress, and you give that to them, and they'll need to give you the information so you can figure out who you want to sue for having defamed you. But what they do is, because that's an English court, and WordPress is like, hey, we're not subject to English court jurisdiction, is then the litigant took the subpoena, the foreign discovery order issued by the court in England, took it to California, domesticated it. So basically they made a California subpoena, and they propounded the California subpoena on WordPress and said, okay, now the California court is going to make you give us this information, so cough it up. There were a number of things that went wrong with this whole process. Actually, they were all wrong that the plaintiff was able to do this. Originally, the way the story kicked off is the plaintiff originally got in touch with WordPress by letter and said, we've been defamed by one of your users, tell us who it is. And WordPress said, hit the road, we don't just divulge that. And so you'll need a subpoena if you want us to do anything. And so they went and they got the English discovery order, and they tried to give that to WordPress and say, the English court says you need to give us this information, and WordPress is like, no, that's not right. Actually, but it was a little bit different. I think they did domesticate it in California. They took it to California, and then WordPress saw it and said, no, there's problems because you have no action you have no action anywhere. You haven't even filed your lawsuit in England. This is all, you take this first step in England to ask for the information, and you need an actual lawsuit if we're going to give you any discovery. So then they went through this whole rigmarole. Just to sum up, because we'll come back to some of these issues. So WordPress said, we're not dealing with this subpoena. So they went and they did another California subpoena, and this time WordPress said, we think we might need to do something. So they notified the user, and the user got counsel, who was me. And I quashed that first subpoena. But that's not the end of the story, because they decided no didn't mean no, and they went and they got another subpoena, and I quashed that one too. and quashed it and joined it and got a fee award. And we're going to talk about some of that later because there's a whole bunch of issues about, we had a happy ever after ending in this story, but it exposed a whole lot of wrinkles about what tends to go wrong. So that's my type of issue.
And just to take a quick step backwards and just talk about the process of a DOE subpoena generally, typically it's a two-step process. So what happens is that you've done something wrong on the internet, whether it's an alleged copyright infringement, a speech tort, somebody alleges that you've misappropriated a trade secret or wants you to appear as a witness in a case. The first step is going typically to the online service provider. So in your case, it was WordPress.
Right. Somebody who in theory has identifying information, the subpoena is on them as a witness for, we would like you to tell us who this person is. And but the only way they can be compelled to produce this information is by subpoena unless they feel like telling you. But WordPress said, no, we don't feel like telling you. You'd have to actually have a court force us. So they use the subpoena as the mechanism for the court saying, okay, you need to come up with this information.
And then generally the next fight is going to the actual internet service provider to link the IP address to an actual subscriber. We just wanted to quickly go over what a subpoena is not, because this is much different than what we see in a criminal context. This is not a search warrant. These happen exclusively in the case of civil litigation, and it's not an order under the Stored Communications Act, which is a different mechanism by which people can get subscriber information. So Erin, do you want to talk a little bit about your copyright cases?
Sure. What we're really getting at is there are different vectors to attack anonymity online, and so many people participate in BitTorrent exchanges, so many people participate in commenting on online forums or wherever, and they do so thinking that because they can make up a pseudonym that they're going to stay anonymous, and increasingly that's not the case. Largely my practice is defending BitTorrent defendants, and in those cases, and I represent several hundred people every year who are identified only by IP address by a forensic expert for the owner of a copyrighted movie, let's say. And they want to take that IP address and translate it into a live defendant that they can sue for damages. So they file, as you probably all know because it's very well reported, these swarm joinder large-scale lawsuits, usually now pursuing anywhere from 20 to 80 defendants per lawsuit, and issue a subpoena to the internet service provider demanding the name, the MAC address, and a number of personal identifiers about the subscriber. The problem with this is that the courts, the federal courts across the country, run the gamut in terms of where they see the DOE subscriber having any rights to privacy. In the Northern District of Illinois, where I do the bulk of my practice, there are judges that have held that the DOE subscriber doesn't even have standing to challenge the subpoena, which flies in the face of Supreme Court cases and flies in the face of other places in the country, like in Florida, where they say an IP address isn't a person, you're not getting this person's name this way. So there's no, and there doesn't always have to be, but there's a massive split between the circuits. So depending on where you live, you can either be identified with the wave of a hand, or you have a judge in Florida who dismisses the whole case because an IP address isn't a person, and that's going to be the end of it. In the Northern District of Illinois, we have 2 or 3 judges who've said, you can't even file a motion to quash. You don't have standing to quash a subpoena that's not directed to you. From the litigation perspective, and I'm speaking mostly, I realize, to policy and advocacy people, we need you guys because, for me, I represent, in any case, a person or a group of people who have their own liability issues, their own interests, and their own economic limits to what they're able to do. So often I'm not able to raise in front of a judge who said the person doesn't even have standing to challenge the subpoena, filing a motion to quash and challenging that subpoena and pointing out how many other courts of equal standing have said that they do. When I know this judge isn't going to turn around and I've got a client who doesn't want to pay to make that fight and lose, it's really hard to do. It's helpful to us when we have people file amicus briefs and come in and make those policy arguments because they're important. Because an IP address clearly isn't a person. And it's impossible for them to prove simply by obtaining someone's identity who the actual infringer was. It could be a neighbor, it could be someone else in the house, it could have been a visitor, it could have been any number of people. And what we're looking for is, and I think it's important to try to have a goal toward, is to have some sort of uniform policy, a uniform standard of measuring when can you pierce and obtain someone's identity in a civil context where it's nothing more than an alleged copyright infringement or an alleged defamatory comment online. Now, it happens obviously in civil litigation, and you've got subpoena power, but where it diverges across the country is when you have states that have laws that permit pre-suit discovery. You don't even have to have the lawsuit filed yet, and you can file things and issue subpoenas to get people's identities. I have experience with this because we do have a rule in Illinois that allows it, and it's called a Rule 224 petition. You don't have to file the lawsuit. You file a petition that says, I will have a lawsuit. These will be my claims. And because of that, I'm seeking the identities of these 300 people. Fortunately, in fact, just a couple of weeks ago, I won an appeal of one of these cases filed by a law firm known as Prenda, where they were seeking 300 identities of people from all over the Midwest in a case they filed in St. Clair County, Illinois. The St. Clair County judge allowed the petition and denied my objection. We have 40 objecting DOE parties, of whom I represent 19 or so. And we appealed the judge's ruling when he said that they could disclose the identities, or that they had to. And just 2 weeks ago, the Court of Appeals reversed that ruling and said no. An IP address is not a person, and you can't use this mechanism to unmask a DOE IP user. And I'm hoping that this case will deter future attempts to use this pre-litigation pretext to obtain the identities of hundreds of people at a time, to send them a letter basically demanding money lest they actually be sued.
In California, by contrast, California by rule says no litigation discovery. It's one of the jurisdictions that says this is uncool, mostly because, as we see with Erin's cases, in theory, it's like, I have a meritorious lawsuit. I need to know who to sue, who my defendant should be. Well, okay, that starts to sound compelling for why you should find out who the person is that you need to sue. But in reality, when you can help yourself in a really costless way of just finding out who your enemies are, you never really have to follow up with that lawsuit. You can make their life hell in any number of ways, extrajudicial, or sending threatening letters, or threaten the actual lawsuit, but you start to get a lot more divorced from the actual merit of your underlying claim. So what happened in my story that I did is England basically has pre-litigation discovery. They went before the judge and they said, my feelings have been hurt, we've been defamed, and the judge was like, well, actually, eventually I got a bit of the transcript of this hearing, and it was terrible by American standards. It's ex parte, which means you've only got the side saying, I've been injured there. You have no defense pushing back on the idea that there should be this discovery at all. And the judge basically deferred to the lawyer. There's some comment in the transcript of, well, I see you've done 30 such petitions. They're called Norwich Pharmacal orders. I've seen you've asked for about 30 of this. If you tell me that this is a good excuse to give you your pre-litigation discovery, I'm totally happy to defer to that. And actually, that's one of the things that WordPress had pushed back again, because they said this is pre-litigation discovery, which is explicitly not allowed in California. California has something in its civil procedure code that says, no, you don't get to do these fishing expeditions. If you want this information, you're going to actually have to have a pleading that you've now, when you sue somebody, you put a stake in the ground that sort of exposes you to consequences. If your lawsuit is really unmeritorious, it can be subject to sanctions, you can be subject to counterclaims. It's a big deal to sue somebody, but it kind of sticks your neck out a little bit. Plus, it puts the other side on notice so they can put forth any sort of competent defense because they know what they're being accused of. So the states that say you can't do this, I think it's one of the reasons we want to talk about vectors is we've got all these jurisdictions all over the country, all over the world, and the rules are different. And the fact that there's differences causes sort of this arbitrage problem, which we call forum shopping, where like California might be very nice and very protective of rights, but if people can avoid the California courts and cause harm to people on the internet in other places via intermediaries in other places, it doesn't really matter how nice California's laws are because they're subject to end runs. So in our stories, we want to kind of talk about what works, what is protective, what doesn't work, so that ultimately we can get every jurisdiction on board with, if we think we want to have privacy on the internet, what realistically needs to be in place so that civil litigants can't exploit that. But just before we move on, one other comment I want to make with what Erin said was, what Natalie had said is we're not talking warrants, this isn't government subpoenas or search warrants, but a subpoena is essentially state action. When a California court enforces a subpoena, that is the California court making state action against the person whose interests are affected. So when you push back for First Amendment grounds, you're not saying that the private party is violating your First Amendment things. You're saying if the California court forces my identity to be divulged, that is the state action that is against my First Amendment rights. So that's part of the alchemy of how we think these things through. So it isn't just, private parties, let them tussle it out themselves. When you start leveraging the courts, it's a much bigger deal.
And I just wanted to briefly mention that in addition to these kind of procedural rules where we see differences, in California we don't have pre-litigation discovery, in Illinois we do, maybe, used to this effect. We see different substantive standards being applied. When parties push back on these subpoenas, we have courts applying different standards. Some of them require your complaint to survive a very high standard. So, have you stated with specificity your claims? Can you survive a motion for summary judgment, essentially, or a motion to dismiss? And then we have some courts who just don't look at the underlying pleading at all, which is really quite scary when it comes to something like this.
Yeah, there was a case, hey, we're in Virginia. Hi, Virginia. There was a case in Virginia where the standard was very light. Like, did the plaintiff have a good faith belief that the person whose identity they were trying to get had done them wrong? But that's a very, very low pleading standard that doesn't really incorporate any sort of counter argument for, well, yes, maybe they would be the person you want to sue, but it doesn't mean that, the comment was actually defamatory or that, California's test is something, have you made your prima facie case that what you're complaining the person did, do you actually stand a snowball's chance in hell of winning your case if you actually got this identity? It's not the toughest standard there could be, but it's something more. It's, did you say, okay, this person injured me thusly in the way that the law is going to recognize, and have you any sort of evidence also sort of at the ready that can prove that not only are you going to accuse the person of this, but you might actually stand a chance of winning? Because if the answer is no, it's just way too costly to start popping people's anonymity bubbles just to take a chance. So there likes to be, even in that standard has some sort of threshold that the plaintiff needs to overcome.
Yeah, we have that in Illinois. The test is whether you could survive a motion to dismiss. And if the claims that you're trying to make against this person who you want identified aren't going to withstand that test, then the court says, well, then you can't have their identity. And the landmark case in Illinois for that is not all that old, and it involved an online speaker who got into a flame war in the comments section on a local newspaper's website. And it turned out that he was arguing it was an article about a local politician who was running for local office. And her son, who happened to be 14, got on this article on the newspaper's website and made a comment about his mother. Didn't disclose he was the son. And some guy got in a flame war with him and started saying some really outrageous and potentially criminal things and making threats. When the woman running for office saw the comments and saw the threats towards her son, she filed a lawsuit seeking to identify the speaker because they wanted to determine whether or not this guy was actually a threat to her son. And despite the fact that these comments were way over the line and threatening and sexual and violent, the trial court judge, who was a month from retiring, said, yeah, identify him, that's fine because this is scary. But they did appeal, and the Court of Appeals set that standard and said, we don't see how she could prevail in a defamation case or any other legal action that she's pled here against this person if he was unmasked, and therefore you can't get there. We were able to translate that into more of and this is where they try to avoid, the difference between doing copyright law or some other type of law, because copyright law, obviously those cases have to be in federal court. And what they do is they try to plead Computer Fraud and Abuse Act, or they try to plead some other claim that can keep them in state court to try to get at these names. And where it's important, I think, for the policy community is you have a person who's identified by a username or an IP address. The IP address could be anyone in the family, it could be a kid. But when the core goal is simply to obtain that name to apply pressure to get economic relief, it's important for the advocacy community to come in as they have. And I've worked with the EFF on some amicus briefs in some of these cases where I didn't have an actual defendant I was representing, to show the court that it's really important that we make clear what is an IP address, what is an online speaker in terms of a username, and when is it appropriate to identify these people publicly, particularly in a litigation context where their name is going to be put into the lawsuit, it's going to be a permanent public record, and even if I can get the court to later remove the name, which I sometimes can, by the time that lawsuit is 10 hours old, it's been replicated so many places online that it's impossible to permanently erase or even come close to getting rid of. So at best I can tell someone, well, now you've been named, we can get it off the court's public docket and we can seal the documents with your name on them, but so if someone does if you're applying for a job and someone does a background check and they look at the court's docket, they're not going to see it. If they snoop around online long enough, they might find your name associated with this lawsuit, which maybe in a copyright case for software or for a movie, a mainstream movie isn't bad, but I also handle a lot of the pornography cases where people have an additional, social concern. So, and those concerns are heavy. There's family concerns, church and community concerns, and those companies bring an incredible amount of pressure to bear when they're talking about disclosing someone's identity or pressing to have it disclosed. And like I said, in Illinois, that name's getting disclosed. The courts have been incredibly clear about that. The best that I can do is to get an order from the court saying, and this was hard to hammer out, I finally got the courts to agree that, look, fine, if you're going to insist on giving them the name, that's where we're at. And I think it's wrong, but that's where we are. But I can get the court to enter an order saying you can't disclose the name publicly until this case goes through discovery and if you can survive dispositive motions. If you can prove that you have a case to win and this is the guy, maybe his name has to get disclosed later. But until you prove that this is the guy and you're not just shooting in the wrong direction, you are not allowed to publicly disclose the name. And that's a pretty good win on that battlefield, but it's nowhere near enough. And I feel like we really need the policy and advocacy communities to get more involved in these cases and to help us to point the courts and pressure the courts in the right direction in terms of allowing these identifications and disclosures, because there are real social and economic costs to my clients when their names get out there, particularly when they're not the infringer or they're not the speaker or what they did isn't defamatory, and ultimately you're going to win, but still your guy's name is out there and maybe he doesn't want that or his employer doesn't want that.
Just to make clear, the right to anonymous speech is clearly protected by the First Amendment. There's case after case after case that makes that very, very clear. So we don't have to win that policy argument of should we have anonymous speech. That's already there. I guess we need to sort of pick that up for some of the conversations about what the government wants to do to puncture things. But that's not really an issue for the defense. The question is there ever a case where we want to compromise it? And our judicial system has accepted that there can be balances, but there is a question of how well they balance. What are the tests they're going to do internally? And then there's logistical issues of, is this even humanly possible to actually to defend things?
Well, that's true, but also when you start talking about, if you're talking about straight speech, if you're talking about a comment on a forum somewhere, that's clearly speech. Is what you look at online speech? Should that be protected?
The right
I think
to
it should,
read,
but that's not how courts are applying it. When you come into a copyright case and I try to tell a judge that my client, in opposing a subpoena, has a First Amendment argument to make, you have a great number of federal judges who will say, I don't see a First Amendment issue here, because they don't see online activity in the form of accessing media content as speech.
And I worked for the Berkman Center and monitored DOE subpoenas, and we saw a number of plaintiffs trying to blur the line between online speech and copyright infringement. Really just toying around with, what this person is saying about me has pissed me off, and then they try to turn it into a copyright infringement claim because we've had courts refuse to acknowledge that there is a First Amendment interest in infringing a copyright, and so they're really trying to evade precedent.
Or even in access, where I say, I worked with the EFF on an amicus brief in Malibu media litigation, where Malibu files these copyright cases. They're a pornography producer, so they file lawsuits against many, many people, and each defendant is accused of downloading anywhere from and distributing anywhere from 12 to 112 pornographic films. In addition to filing the lawsuit and the list of movies that were alleged to have been directly infringed, they were filing an exhibit they called Expanded Surveillance, which was other copyrighted works, not owned by Malibu, and not all films, supporting the idea in their mind that this is really a copyright infringer, this is a bad person, and here's all the other stuff they're stealing. Some of it was like ebooks, software, magazines, but a lot of it was also pornography not owned by Malibu that, unlike Malibu stuff, which is very soft-core, airbrushed, listing hardcore films with very racy titles, and so racy, in fact, that they got the attention of a federal judge in Wisconsin who sua sponte said, "You better explain to me why you filed this, because I think that this is not designed to support your copyright case. I think this is meant to embarrass somebody into giving you quick money." And so I got involved with the EFF in asking the court to sanction Malibu for filing this, for bringing that kind of pressure to bear on a person who may not even be the infringer, but who may be pressured to give up a great deal of money to avoid being publicly associated with the works listed on that exhibit. And that did happen. They actually were sanctioned in Wisconsin by 2 different courts in Wisconsin and by a court in Illinois.
But copyright is a scary vector. There's sort of how things work. Like when I deal with like the quashing of foreign subpoenas, usually it's defamation related issues, which is a big deal, and I don't want to gloss over because obviously that's a crux of where a lot of the action is, that people feel so injured. But it could be other things, trade secrets or something like that. But we're talking about the difference between state and federal court, and sometimes federal court has better protections and sometimes the state court would have better protections. And like in California, I could sit here and make a list of things that need to be better in California, but it's not a terrible place to have to defend us, to try to quash a subpoena. But then there's another type of subpoenas. So the ones that Erin is doing are from the Federal Rules of Civil Procedure, where there's a copyright related case and this subpoena spawned off the case. There's also something connected to the DMCA, the Digital Millennium Copyright Law, it's called 512H subpoenas, where an intermediary, and there is an argument here that if an intermediary wants to not be subject to the lawsuit for copyright infringement other people have made on its site, let me just give you a very quick example, like YouTube. People post their videos to YouTube, and when they're posting the TV show that they saw last night, it's not their copyrightable material, they may very likely be infringing, and YouTube really can't sit there being in the crossfire of this lawsuit. So the Digital Millennium Copyright Act is designed to protect something like YouTube, to say, if you take these steps, meet these requirements, you won't get sued. Your user may get sued, but you won't get sued. And one of the requirements, arguably, is under 512H. It's a subpoena mechanism that the copyright holder can say, I really want to sue whoever did upload the movie, and I need a way of finding out who that was, so they issue subpoenas under this mechanism. And there's a question about whether the intermediary has to comply with these subpoenas, and there's also a question of whether the users themselves have any grounds to try to quash these subpoenas, and to what extent will their First Amendment interests in their anonymous speech be at all relevant. These subpoenas are generally discredited. There was a big case a couple of years ago saying you can't use 512H subpoenas for file sharing type cases. But last year in California, I don't know where this has gone, but I've seen something on the record that said, what if it was a blog post? What if you had a WordPress blog, for instance, and you posted somebody else's book? Because that's an easy example. You copied pieces of the book and you put it in your blog post. Does the intermediary have to comply with the 512 subpoena? And there was an attempt, so Automatic was the intermediary in this case, and the user tried to quash the subpoena to say, it's my blog, I'm using it to speak, I shouldn't have to lose my anonymity in order to defend this copyright-related infringement for content that I posted. And the court, there's a very unfortunate ruling where the court's like, yeah, I see your First Amendment stuff and it's really no big deal here, you should have to stand and answer for your copyright infringement thing. So that's a big vector, but then there's another troll out there that is trying to use 512H subpoenas in the BitTorrent context anyway.
Yeah, and I get I probably get 10 calls a week about this. There's a company called CEG Tech, and they send these 512H notices to internet service providers who are required, with regard to any subpoena, they're required by federal law, by the Stored Communications Act, to forward a notice to the subscriber. We've received a complaint about you and your use of the internet. The law does not tell them how they have to advise the subscriber. So you have the larger ISPs like Comcast and AT&T who have chosen to, so what CEG Tech does, let me backtrack, is they send this notice, and they send with it the notice that they would very much like that subscriber to see, the threat notice. Go to our website, pay $200, you've infringed our copyrighted work. So some of the smaller ISPs who are maybe a little less courageous and a little less advanced will just forward this notice on to the subscriber. So basically, they get something from their internet service provider that says, there's a subpoena, you've done wrong, but you can pay to get out of it. There's no lawsuit. It's just a subpoena issued under the act. But they get scared, and they're like, oh God, maybe I gotta pay $200 to make this go away. They're gonna unmask me, they're gonna find out who I am, which they're not, because that's not what the subpoena is designed to do. But people get frightened about it. Comcast and AT&T, for example, have decided they're not gonna carry water for CEG, and they notify the subscriber and comply with their legal requirements, but they don't forward that notice. And they don't, they basically say, someone has complained about you. We're not gonna carry water for them and give you their little notice and help them advertise themselves, but we're gonna let you know. There's no litigation, there's no lawsuit filed, there's no lawsuit pending, and there's no subpoena threatening to unmask them. But a lot of people, lay people, don't know that. So they will sometimes go to the website listed on the notice, which now is tracking their IP address, and they will pay the $200 per movie because they're afraid. And the reason they're afraid is they see all these websites and all this conversation online about BitTorrent subpoenas and about people getting sued and people paying big damages, and they get frightened, and so they pay up.
So you guys have touched on several challenges related to defending these, but I just wanted to ask a couple of questions about some really just kind of basic issues that stand in the way of, standing up to these types of orders. And one is finding counsel in the first place. And I think Kathy's experience in, defending and working kind of alongside WordPress in the St. Lucia Free Press case, you took on that for free at first.
I did take it on for free. So having counsel is a really good idea. This is hard, this is scary, and you want somebody else to be able to do your sensible thinking for you when you're in a tough spot. So the fool and his lawyer thing is definitely true, and it's also very difficult if you're trying to protect who you are to actually to show up into court and try to protect your identity, which you've kind of inherently revealed just by showing up. So there are people, there's a lot of dedicated counsel, particularly I jumped into a free speech case. There's a lot of dedicated counsel that really want to stand up for free speech, and that's great, but it is much better when counsel can get paid. It means there's more counsel floating around. You want a chance to have that. So what we start to see, particularly in the free speech context, is a lot more fee shifting statutes. Many of you have probably heard of anti-SLAPP. Which basically means if a SLAPP is a strategic lawsuit against public participation. It's the kind of lawsuit that a bully will file against somebody who's posted criticism because it's trying to scare them into shutting up, because let's face it, getting a lawyer to fight anything is really expensive. So the idea is it chills people from posting legitimate criticism because they're not going to be able to deal with the consequences, even to defend themselves and vindicate themselves. That's the process itself becomes the injury of having to do that. So a lot of anti-SLAPP statutes are, if you file this kind of threatening case and you lose it because it had no merit whatsoever, you were just doing it to chill public participation, you're going to lose, and you're going to have to pay for the attorney fees that the other side had to expend. This is a good thing if you want to kind of clamp down on this sort of litigation abuse. But in California, for example, the anti-SLAPP statute wasn't available when the lawsuit was filed in another jurisdiction, used to kick off the subpoena that showed up in California. And there was a case where also the EFF and Public Citizen had quashed the subpoena and then moved under the anti-SLAPP statute to say, okay, we defended a user against what was essentially having their identity exposed for a SLAPP. Where's our money? And the court said, no, no, no. California's anti-SLAPP only works if an actual complaint was filed here. Since the complaint wasn't here, no money for you. That fee shifting statute is unavailable. So, so some advocates, the EFF and the California Anti-SLAPP Project, went to the legislature and got a nice a statute in the Code of Civil Procedure to say, if you win by quashing the subpoena, now you can get fee shifting. And California refers this to, it's the doctrine known as the private attorney general doctrine, which is to say when these issues are at stake, you want to make sure lawyers are at the ready to vindicate this important public policy. Because it's not just the user whose interests are at stake, it's all users everywhere who want to make sure that they're free to speak as well. Because if one user can be chilled, another user can be chilled. So one of the challenges for getting counsel is making sure, it's really advantageous for making sure there can be counsel if the counsel can get paid. Although now we tip a little bit into that issue of forum shopping that I talked about where, so forum shopping was happening in California when it turned out that you couldn't get fees for fee shifting. So they were taking their SLAPP lawsuits, not filing it in California, filing it in like Nevada. That's forum shopping because they picked Nevada because, hey, we file in Nevada, which now actually has an anti-SLAPP statute, so this is a terrible example. But if they filed it in another state, they could get out of it for free. But then when we clamp down on that, now there's no reason to try to run around California. But California has fee shifting, not every state does. That case I mentioned in Virginia, which I keep remembering we're in Virginia, sued Yelp. Yelp is a San Francisco company that the subpoena should have been propounded on Yelp in San Francisco, which would have put this whole operation of defending against the subpoena under California's rules, including for fee shifting, things like that, and they didn't. So the Virginia court said, no, we have jurisdiction over you anyway, you have to answer this in Virginia. Now it's a Virginia matter, a Virginia subpoena, and I don't think the rules protecting, I don't think there's fee shifting, I haven't looked this up, but but this whole mechanism of how you're going to quash is subject to Virginia's rules, which may not be as generous for protecting the users as California's. So that's one of the challenges for getting counsel.
The fee shifting is incredibly important because I probably take 200 or 300 calls per week from people who are looking to protect their identity from some sort of litigation attack. And invariably, one of the top 3 questions is, what is this going to cost me? People have the resources that they have, and they may believe as strongly as anyone that they should be allowed this free speech and that they shouldn't be subject to disclosure, but at the end of the day, and the people who are bringing these claims are doing it for a reason. They're doing it to get money. And in the copyright context, in the BitTorrent context, they found that sweet spot. They found that amount of money that most people have or can put on a credit card to give in exchange for not having to worry about litigating it, not having to worry about spending money that they won't get back, despite the fact that copyright law is a loser pays system. So if you're wrongly accused and you do litigate it, you win, you're going to get your attorney's fees and costs paid, but people get scared about protecting their resources. And so the fee shifting and letting people know that if you win, you will get your money back. Or if this is a SLAPP and we win, you will get your money back. And under some statutes, you can get triple damages. You can get multipliers. Minnesota's anti-SLAPP is very robust. And right now, I have a defamation case in Illinois where we are trying to apply the Minnesota anti-SLAPP statute because it's much more robust than Illinois'. And you had a question?
Yeah, it's a very simple question. Is there a legal definition for anonymity or pseudonymity?
No, I mean, it depends on the context.
I don't think there's not a technical definition. Certainly,
Yeah.
there's
It's just I hear the word used a lot, but it seems to have different meanings every time it's used.
Well, there is, it may not be what you think you want, but there's a lot of federal Supreme Court precedent, which is basically, if the Supreme Court has said, you can rely on this is the law of the land, that explicitly uses the sentence that's something along the lines of, the right to anonymous speech is enshrined under the First Amendment, and it's unequivocal, and that is there. That's not to be quibbled with. It's been said and repeated. What will happen when it gets litigated is people will say, but it doesn't really implicate you weren't really exercising free speech. So people will try to carve around the edges. But you have the right to anonymous speech. So,
well, what does that mean, though? That's what I'm asking.
And there hasn't been a line drawn between you have a right to an anonymous Twitter handle. We have.
But I think the way that I hear judges when we talk about it in court, which we do a lot in Illinois, is they'll refer to someone remaining anonymous, whatever, and being allowed to proceed by pseudonym. So if you've sued John Doe's 1 through 50, and my client's IP address is number 12 on that list, he is then henceforth John Doe 12. And that is his pseudonym. But I don't see them making a big distinction because they're so reluctant to get into that issue too deeply. I think in the Northern District, the deepest opinion that I've gotten was early last year by a judge who really went into the issues and said, you know what, there's enough potential for abuse here that I'm going to let you get the identity, and I think you get that, but you don't get to publish the name. Not till we sort out the bodies, not till we figure out if this is really the infringer or really the person against whom you can recover.
Actually, and I want to toss one other thing out from California. It's not going to be the clear definition that I think you're looking for, but I said that one of our sources for you have the right to anonymous speech is federal Supreme Court legislation. California has a very dysfunctional constitution. It's not like the federal one, which suffers from perhaps vagueness and incompletion about certain things, but is kind of orderly and you know, it's a little clear, as opposed to the California one that every time someone in public policy thinks of a good idea, they tack it on to the end of the Constitution. So it keeps getting longer and longer and longer. But one of the things that's in the California Constitution is an explicit enumeration of the right to privacy. Not in the way that we see it under the Fourth Amendment, but it's like California's a right to privacy. It says it very explicit. And what's starting to happen on the subpoena quashing things, in fact, there was a case that actually post-dates the one that, the quashing that I did, that says that the California right to privacy is what's going to clamp down, and you're not even relying on the free speech things necessarily, but that a California court does not get to violate the California Constitution and a right to privacy is implicated. I mean, some of what I'm saying is, let's get everything into California, which conveniently is where all the intermediaries are. Like Twitter is there, WordPress is there, Facebook is there, although in a different county. This is actually kind of handy if we can actually make it, like particularly the free speech stuff happens. Let's get into California. I'll take another one of these cases with fee shifting and some really nice code of civil procedure. But that said, I'd like even California's code to be tighter and better. The dates to figure this out by, like one of the challenges for getting counsel, my poor client like got the subpoena and then was like, and the date that WordPress had to respond by was like 3 days later. And it made it really hard for the client to get counsel because people were like, I'd really like to help you, but I can't do that in 3 days. So longer return times. One of the things was the English discovery order had no signature attached to it. And I'm like, is this even valid? So some sort of verification that this is actually a valid subpoena and that we would have to actually do something, you know, substantiate that. That should be a rule. Where is the pleading? In this case, there was no pleading, but there's even issues that, you know, if you filed your lawsuit in some place where it's not pre-litigation discovery, you actually have filed your pleading. I need that pleading so I can say that, no, you haven't met your prima facie case to that you'll actually win this. It's a real pain in the neck if I don't actually have that pleading in front of me. So there's a lot of logistical issues. Then we ran into a situation where all the fee shifting in the world is no good if you can never collect that from the plaintiff. In this case, my plaintiff was foreign and openly bragged when they did the reply in the next, when I had to quash again, we have no intention of paying this unless you follow us to England and force an English court to make us pay, which is not practical in any way, shape, or form. So I ended up actually getting the money because I argued that the lawyer who issued the subpoenas should be jointly and severally liable for the fee award. I won. This is a big deal, and I don't take lightly this idea about putting lawyers on the hook for their client's stupidity. You want to make sure you have members of the bar able to be true advocates for all sorts of causes of action and interests in clients. We really can't do our job very well when we completely get on the hook. But it's not to say that we live in a system where lawyers are never on the hook. You're not allowed to, like for instance, I talked about filing a lawsuit and I said you could be subject to sanctions if you filed a really terrible one. The lawyers can be subject to sanctions. We have something in federal court called Rule 11 sanctions, and a lot of states have their own versions of it, which is if there was no good reason to think that your client could ever possibly prevail on this, no, you've caused everybody a lot of trouble and expense, you're going to be liable for it. So we will hold lawyers accountable. And in California, one of the things with like this interstate discovery, when you go jurisdiction to jurisdiction, the complaint was filed in one jurisdiction and the subpoena is another. They've got some acts, like California implemented something that's like the Uniform Discovery Act, something like that. And it's actually kind of handy because litigation's big, it's expensive, you've got so much going on, you really don't want to have to jump off over too many logistical hoops to get the discovery that you need and may very well be entitled to. So they streamlined it. And so it's pretty easy. You take the foreign subpoena and you domesticate it. Lawyers can self-domesticate it by using the appropriate form, attaching the appropriate documents, checking off the right boxes here. And it's very easy. But in the ones we were doing, the California attorney, by privilege, by being member of the bar, got to self-issue these things, and there's a credible argument to say you should be on the hook for this crap that you're suing that everybody has to now react to. In this case, I also won because it was 3 subpoenas. I mean, really, you don't take no for an answer, you keep trying, and you have no intention of, your client is not paying the other judgment, so there are a whole bunch of public policy reasons that my judge ultimately is like, this is not a hard call, dear lawyer, you're going to pay. But I was very lucky, and I think it's a colorable argument, even if it had just been 1 subpoena, that the lawyer could be on the hook. But this is an issue. If the plaintiff who's doing this abuse is essentially judgment-proof, you're never going to see the money. They're just going to be able to cause whatever trouble that they want, and there's no real mechanism to make sure that they can't. So that's something that, as a matter of public policy, we would want to make sure is the case in any jurisdiction, to make sure that the idea of having fee shifting is a good deterrent and it's a good cure, but we want to make sure that this is a realistic safety valve for this problem.
So we have just a few minutes left, and I wanted to kind of step out of the courtroom and into just the practical advice that we can give internet users everywhere. I think, with anonymous apps like Secret and Whisper taking off and people kind of maybe being misled into believing that they have, these protections, what can we tell internet users?
I think you're not as anonymous as you think you are. And I mean, in a sense that I don't have to say that, because now that we're sitting here having the NSA discussions, we kind of already know. But I think this is true. Like, I've had calls from prospective clients who were pretty darn sophisticated in covering their tracks, but ultimately there was still one thing where they accidentally did one transaction as part of this whole chain of obfuscation where they did it at home. So they sort of are recognizing, well, as a practical matter, you can get the lawyer, but it may not be worth quashing because it's a lot of effort. And okay, we can make this subpoena go away, but your identity is still going to be discoverable via another avenue. If you're an anonymous blogger, don't comment anonymously on another blog, because all of a sudden, let's be clear about who intermediaries are. WordPress is an intermediary, Twitter is an intermediary, YouTube is an intermediary, whoever is running their own blog is an intermediary. And like, if you've ever done that, when you get a comment, you're getting an IP address that shows up, and that's information that somebody might want to subpoena, because they're just plunging around in the dark for, I know somebody's injured me and I'm doing this investigation to figure out who. And I may have to turn over a lot of rocks to do it, but the first rock is, okay, you've got this. And this was unfortunate because there were 2 anonymous bloggers who were being threatened, but one had commented anonymously on the other person's blog, and it screwed up the representation because in theory there was bargaining chips that one of the bloggers had, where maybe they could bargain away protecting their anonymity in divulging the information they had about the other one. So that was really unfortunate. And so I'd say as a tip, if you think you're implicated, get your own lawyer. Don't try to share the counsel, even if you think it's a cost-effective way to do it.
Yeah, because it isn't always. And I think that if you're a person who, and it's great to be a zealous advocate for your cause and for your beliefs, and I admire it greatly. And as sort of a mechanic in the courtroom, I appreciate when it's brought to bear and it's something that I can't do because I have other duties in the case. But people who wish to be zealous and who wish to do that really need to be informed. Because once they cross the line from zealousness into something that is actionable, they can have had all the good intentions in the world and done all kinds of good, but once you cross that line, it's unfortunate, and a judge isn't going to dismiss the case, and you are going to have to answer for it, no matter how much good came before. And I have people who I see do so much good work, and then they just in a moment of anger or passion, whatever, do something that is arguably defamatory or say something that is actionable. And people just need to be aware that, what free speech means in this country, it depends on the context you're talking about it in. And it doesn't mean that you can say just anything. You can say a lot, but if you're going to be online and zealously advocating for your cause, you need to be informed.
And at the same time, I don't want to say free speech is completely dead. I mean, I'm happy to take some legal bullets to try to defend this, but I would like to make sure I have the right tools that I can do so effectively. One thing I want to make sure I put into the vocabulary of our discussion is the Speech Act. I don't know if you guys are familiar with that, but typically an American court will give, the concept full faith and credits in the Constitution. It basically means if another court of competent jurisdiction has issued a ruling, but let's say it was a court in New York, here's a judgment against somebody in Virginia, it means that the Virginia court will respect the judgment and enforce that using their courts against the Virginia resident. So that's always happened, including internationally, that we would enforce truly foreign orders. Like even if there was a verdict in England and the judgment is against a resident of the United States, a Virginia court would enforce it, a California court would enforce it, etc. Except we always had the standby of we won't do it if it offends American public policy, like if it was something that you never would have been able to get this verdict over here because it would violate some constitutional principle, including, for instance, the First Amendment. So, we don't regard England as a very good protector of free speech. There's all sorts of libel tourism. So typically, that's very nice that you got a libel judgment in London. You're never going to enforce it on the person who did the speaking in the United States. Until one day a New York court was like, nah, we'll go ahead and enforce it. And that was really bad because that starts to set a precedent and this shouldn't have happened. So Congress passed the Speech Act, which basically put into statute to say, if you've got a jurisdiction, a speech-related thing in a foreign jurisdiction that does not respect free speech, like the First Amendment does, you don't get to enforce it. This was really handy, but I tried to use that to quash my subpoenas, and I didn't really get very far with it because the Speech Act says we won't enforce final judgments, but I had a discovery order, and I was trying to argue that that discovery order functioned like a final judgment, that it's just as if there was a final verdict saying, yes, you libeled them, that in and of itself was precluded by the Speech Act. And the judges I was arguing before were looking at me skeptically and not really buying it. On the other hand, all the judges looked and said, but we respect the findings of Congress to say that, a lot of these jurisdictions are really terrible on free speech, and we really don't want to subjugate our domestic concepts of free speech protection to these foreign ones. But one thing that might be worth having, especially because we're talking about forum shopping, where California's got good tools to work with, but Virginia maybe not. Federalizing this to some extent, including about what happens with, the next liable judgment against some of these intermediaries. Why would they try, if they can go to Virginia to do this, why wouldn't they, because they're going to lose if they go to California. So, but if the Speech Act says none of these things can be enforced, that would be some nice protection, and maybe there's some stuff we can do with that statute to help this cause.
So we have 2 minutes before lunch. Does anyone have any questions before everyone's just hungry?
I'll throw one.
Okay, great.
Yeah, the intermediaries, Yelp really does operate all over because there's restaurants in Virginia and there's people commenting in Virginia. What about, like Twitter or some more centralized service? Do they have an argument to say that you can't file and, we're over here? So you can, and the point of this, the goal here would be to locate in California to have all the tools that you have at your disposal.
Yeah, well, this is blundering into a much more exhaustive topic that I haven't researched adequately, but I was reading that case shortly before we did it because I knew it was an issue, and one of the reasons that Virginia case is interesting is because they used a very low test. Like I was talking about the prima facie case, do you stand a chance? They had the good faith test, which really isn't sufficient. It's like, yeah, it might have been the guy. It was not hard to sort of say, go ahead and puncture this anonymity. But I noticed this other thing, because I kept wondering, why was this a Virginia case at all? And one of the things is Yelp had actually apparently said it shouldn't be a Virginia case at all. We should not have been subpoenaed in Virginia. And the court said, well, you had you
An agent?
had a registered
Yeah.
agent here, which basically any company that wants to do business in any state that has any footprint has to have a registered agent. But now we're running into what would be a larger discussion about internet jurisdiction and where these things are appropriate, because there is a question of, let's say the person who actually commented, this came up in one of the DOE cases of the case was in DC, but the user information, those users were in all sorts of places other than even DC. Have they exposed themselves to DC jurisdiction? When you play on the internet, whose courts have you exposed? If I sit here right now, am I exposed to, I'm sitting here, I'm currently in Virginia, I'm a California resident, my email server, the company providing me my email is in California, their server may be who knows where, and it's a very interesting topic of figuring out what courts get jurisdiction over what sorts of internet speech. Too big to discuss now, but you see one of the implications of when you start doing this mechanism, especially while, some courts have different, some local law is more protective than others, now it matters, because we get the forum shopping.
Any other questions? Thank you very much for joining us.
Thank you.
Thank you.